HAPE Law, Unit 2. And under the law of tort, today we'll be dealing with vicarious liability. Now, vicarious liability is the principle at common law where one person is made liable for the torts of another. The most popular of these is that of employers being held liable for acts of their employees. Now, the law uses the old expressions of master and servant when referring to an employer and an employee. The theory of vicarious liability is that a master is strictly liable for any tort committed by a servant in the course of the servant's employment, irrespective of whether the master authorized or ratified the activity complained of, and even though he may have expressly forbidden it. The liability is based not on fault, but on considerations of social policy. It may seem unfair and legally unjustifiable that a person who has himself committed no wrong should be held liable for the wrongdoing of another. On the other hand, it may be argued that a person who employs others to advance his economic interests should be held responsible for any harm caused by the actions of those employees. The innocent victim of an employee's tort should be able to sue a financially responsible defendant, who may in any case take out an insurance policy against liability. So there are certain conditions that a plaintiff must satisfy in order to be successful in his claim for vicarious liability. So 1, there must be an employer-employee relationship. Secondly, the tort must have been committed by an employee. And thirdly, the employee must have been acting in the course of employment when the tort was committed. So the first one, there must be an employer-employee relationship. A person who is employed to do a job may either be a servant or an independent contractor. An employer is generally not liable for the torts of his independent contractor committed during the course of his employment. This means that it's very important to distinguish between a servant and an independent contractor. The traditional test for determining whether a person is employed to do a job, whether they are a servant or an independent contractor, is that of control. A servant may be defined as a person employed by another to do work for him on the terms that the servant is to be subject to the control and directions of the employer. An independent contractor is one who is his own master. A servant is expected to obey his employer's orders. An independent contractor is engaged to do the work, but he is to exercise his own discretion as to the mode and time of doing it. He is bound by his contract, but not his employer's orders. A servant is employed under a contract of service. An independent contractor is employed under a contract for services. In the first case, the employer can order or require not only what is to be done, but how it is to be done. In the second case, he can order or require what is to be done, but not how it is to be done. A man who is employed as a driver is employed under a contract of service, while a taxi driver is employed under a contract for services. A maid is employed under a contract for service, while an electrician or plumber is employed under a contract for services. The lending of a servant. There are situations that can result in a complicated master-servant relationship. An employer may agree to lend an employee to another employer, or to include the employee with rented equipment. If, while in the employment of the temporary employer, the employee commits a tort, the general employer will usually remain liable. He will not be liable if he can show that he had temporarily divested himself of all control of the employee. It will be easier to show that the hirer has control where the servant is an unskilled laborer under a labor-only contract than where he is borrowed along with a complicated piece of machinery which he has to operate. And an example of this was found in the case of Mersey Docks and Harbour Board against Coggins and Griffith Liverpool Limited. So now the second requirement. A tort must have been committed by the employee. So for the master to be vicariously liable, the claimant must first prove the commission of the tort by the servant. To make the master liable for the tort of his servant, the first question is whether the servant is liable. If the answer is yes, the second question is to see whether the employer must shoulder the servant's liability. Sometimes it may be difficult to prove affirmatively which of the employer's employees was negligent. If a claimant complains of negligent treatment during an operation in hospital, it may be impossible for him to show which one of the team of surgeons, anesthetics, and nurses involved in the operation were careless. The claimant can then call in aid the res ipsa loquitur doctrine. The thing speaks for itself. So in the case of Cassidy and Ministry of Health, the plaintiff was injured as a result of an operation in the control of or more of the defendant's employee surgeons in a hospital. He could not identify the particular individual who was responsible. And in this case, it was held that the hospital authority will be vicariously liable unless it proves that there was no negligent treatment by any of its servants. In other words, the res ipsa loquitur doctrine applies. Thirdly, the employee must have been acting in the course of employment when the tort was committed. Another necessary ingredient in making the employer liable for the tort of the employee is that the tort must have been committed in the course of the employment. The master will not be vicariously liable for his servant's tort committed on his private time. A tort can be committed within the course of the servant's employment in three different ways. A. It is expressly or impliedly authorized by the master. Or B. It is an unauthorized manner of doing something authorized by the employer. Or C. It is necessarily incidental to something which the servant is employed to do. The second and third circumstances have proved to be difficult in practice to identify. It is now accepted that the question of whether a servant's act is within the course of his employment is ultimately one of fact in each case. So, unauthorized manner of doing something authorized by the employer. A complicating issue arises where the employee does something authorized by the employer but in an unauthorized manner. So in the case of Limpus and London General Omnibus, a bus driver had been given express instructions not to race with or obstruct the buses of rival companies. In disobedience to this order, he obstructed the plaintiff's bus and caused a collision which damaged it. It was held that the driver's employer was liable because the express prohibition did not limit the sphere of the bus driver's employment, but merely sought to control his conduct within the scope of his employment. In the case of Canadian Pacific Railway Company and Lockhart, the defendants expressly prohibited their staff from driving uninsured cars on the company's business. One of their employees drove an uninsured car in disobedience of the order and negligently injured himself. The defendants were liable since it was not the acting as the driver that was prohibited, but the non-insurance of the motor car. The prohibition merely limited the way in which or the means by which the servant was to execute the work which he was employed to do. Breach of the prohibition did not exclude the liability of the master to third parties. Under the heading, it is necessarily incidental to something which the servant is employed to do, the court will normally rule against the employer where an employee does something which is incidental to his employment but results in a tort against the claimant or plaintiff. The time and place of the incident will be considered a factor in the case, as shown in the case of Ruddiman and Co and Smith. In this case, a clerk turned on a tap in a washroom 10 minutes after office hours and forgot to turn it off before going home. Adjoining premises were flooded as a consequence, and his employers were sued for the damage suffered. The employers were held liable. The use of the washroom by the clerk was an incident of his employment, and the negligent act took place only a few minutes after working hours. The factor of place arises when an employee makes a detour from his authorized route. Now, for express prohibition, the existence of an express prohibition is a factor to be taken into account in determining whether a tort was committed during the course of employment so as to make the employer liable. A distinction is drawn between A. Prohibitions which limit the sphere of employment, and B. Prohibitions which merely deal with conduct within the sphere of employment. Only a breach of the first type of prohibition will take the servant outside the course of employment and thus relieve the master from liability. Again, in Limpus and London General Omnibus Company, a bus driver had been given express instructions not to race with or obstruct the buses of rival companies. In disobedience to this order, he obstructed the plaintiff's bus and caused the collision. And it was held that the driver's employers were liable because the express prohibition did not limit the sphere of the bus driver's employment, but merely sought to control his conduct within the scope of his employment. It must be noted, however, that an express prohibition which limits the sphere of employment will absolve the employer, as seen in the case of Clarke and William Brewer Company Limited. In this case, the company's truck drivers had been expressly forbidden to drive trucks on Sundays unless they were instructed to do so. In disobedience to this rule, a driver drove one of the company's trucks on a Sunday without permission and on personal business. Another motorist died as a result of the driver's careless driving of the truck. It was held that there had been a prohibition which limited the sphere of the servant's employment, disobedience to which absolved the employer of liability. In this case, the driver was not using the truck for the owner's purposes and was not driving under delegation of a task or duty. He was not acting as a company's agent and was therefore liable. There's a principle in relation that is called frolic of his own. And the rule regarding frolic of his own states that if the servant is going out of his way against his master's implied commands while driving on the master's business, he will make his master liable. But if he was going on a frolic of his own without being at all on his master's business, the master will not be liable. Where a detour by the servant amongst a frolic of his own, or whether it amongst a frolic of his own, is a question of degree. Both the extent of the deviation and its purpose will be taken into account. So in the case of Joel and Morrison, Joel was crossing a street and was struck down by a horse and cart whose driver was Morrison's employee. The driver had detoured to visit a friend when the accident occurred. Morrison argued that he was not liable for Joel's injuries because the employee had strayed off his path, and was held if the servant, being on his master's business, took a detour to call upon a friend, the master will be liable. But if he was going on a frolic on his own, the master will not be liable. In Whatman and Pearson, it's held that a servant who was in charge of a horse and cart throughout the day drove them to his house without permission for his midday meal. He left the horse carelessly unattended outside his home. It ran away and caused damage. It was held that the employer was liable for the damage. The servant had deviated only a quarter of a mile off his unauthorized route, and the purpose of the detour to obtain refreshment was reasonably incidental to his employment. In the case of Story and Ashton, a driver had been sent to deliver wine and collect empty bottles. On the return journey, he deviated from his route in order to pick up a cask at the house of a friend and take it somewhere else for the friend's private purposes. Due to his carelessness, an accident occurred and the plaintiff was injured. The employer was not liable for the driver's negligent driving on the way to the friend's house. He was clearly on a frolic of his own. Criminal activity by employees. Another set of issues arise where the employees commit criminal acts while on their master's business. For the cases that follow, it is clear that it is a criminal act. It is clear that if a criminal act is committed by a servant in the furtherance of his master's business, the employer will be liable. This is so even if the master did not authorize it. The master will be liable unless the act is so extreme or so outrageous that it cannot be regarded as incidental to the performance of the servant's allotted duties. So in the case of Lister and Hesley and Hall, 3 plaintiffs had been sexually abused by the warden of a children's home owned by the defendant where they had lived previously. The defendant was held to be vicariously liable for the abuse since there was a sufficient connection between the work that the warden had been employed to do and the acts of abuse that he had committed for those acts to be regarded as having been committed in the scope of his employment. In the case of Warren and Henly Limited, a garage attendant, after accusing a customer of driving off without paying for gasoline, assaulted the customer. The attendant's employees were not liable since the act of the attendant was extreme and not so connected with the acts which the servant was expressly or impliedly authorized to do as to be a mode of doing those acts. In the case of Lloyd and Grace Smith and Company, the defendant firm of solicitors employed a managing clerk who was authorized to do conveyancing work for the firm. The clerk induced the plaintiff, who owned a number of properties, to instruct him to sell the properties. He then persuaded her to execute 2 documents which he falsely told her were necessary for the sale, but which in fact were conveyances of the properties to himself. He then dishonestly sold the properties and misappropriated the proceeds. The defendants, in this case, were held liable for the fraud of their servant. It was immaterial whether the fraud was perpetrated by the clerk for its own purposes or that the defendants derived no benefit from it, as he was an agent and an official agent of the firm. Liability of bailies. A bailee is someone who lawfully has possession of another person's property, and when goods are entrusted to a bailee, he will be liable for any loss or damage to the goods caused by his servant, whether or not the servant was acting in the course of his employment. In the case of Bowen and Phillips, the plaintiff took his car to the defendant's garage to have it greased and sprayed. On the directions of the defendant, the plaintiff left the car with an employee who was employed to do such work. Sometime later, the employee drove the car out of the garage for his own purposes and damaged it. The plaintiff sued the garage owner. It was held in this case that there was a relationship of bailer and bailee for reward between the plaintiff and the defendant. Since the bailee had entrusted his servant with responsibility for custody of the car, the bailee was liable for the damage, notwithstanding that the employee was on a frolic of his own. Improper delegation. Where a servant improperly or without authorization delegates his task to a third party, and through the negligence of that third party the claimant is injured, the master will not be liable for the negligence of the third party, but he may be liable for the failure of the servant to exercise sufficient control, so as to ensure that the task was carefully performed. So in the case of Ricketts and Thomas Styling Limited, a bus belonging to the defendant had just completed its journey and discharged its passengers. It then proceeded to commence its return journey driven by the conductor, at whose side the defendant's licensed driver was sitting. While thus being driven, it suddenly mounted the pavement and injured the plaintiff. At the trial, the case was withdrawn on the basis that there was no negligence on the part of the defendants. On appeal, however, it was held that the driver owed a duty to his employees to see that if he allowed another person to drive the omnibus, that person drove properly, and that it was a question of fact whether the driver was guilty of negligence if he failed to see that the person whom he had allowed to drive was a competent driver. A new trial was therefore ordered. Liability for employers for trade union activity. There is evidence that the court will not hold the employer liable for wrongful, intentional torts done by an employee in furtherance of a trade dispute, and this was taken from the case of General Engineering Services and Kingston and St. Andrews Corporation. Vehicle owners and casual agents. The problems that arise with motor vehicles require separate study. Vehicles are frequently permitted to be driven not only by employees but also spouses, children, and friends. The doctrine of vicarious liability has been extended on grounds of public policy to fix liability upon the owner of a vehicle for damage caused by the negligent driving of such a vehicle by persons who are not servants, but merely casual agents of the owner, such as the owner's spouse, child, friend, or stranger, where the agent drives wholly or partly for the purposes of business of the owner. Just as a master is liable for his servant's tort committed during the course of the servant's employment, so the vehicle owner is liable only where the casual agent was driving for some purpose of the owner. If a father asks his son to drive to the store, in the father's car to pick up some crates of beer for the father will be liable for any damage caused by the son's careless driving to or from the store. He will not be liable where the son, with or without his permission, uses his car for some purpose of the son's. In Hewitt and Bonvin, it was established that a father who allowed his son to use his car to take his girlfriend home, the son's negligent driving injured the plaintiff, and the father was held not to be vicariously liable for the injury. In the case of Nicholls and Tutt, the owner of the car asked a mechanic to test drive the vehicle after carrying out repairs. The mechanic injured the plaintiff by driving negligently. In this case, it was held that the mechanic was driving as the owner's agent and the owner was vicariously liable for the damage. Presumption of service or agency. Sometimes it is difficult, if not impossible, for the claimant to prove that the driver of a vehicle was an employee or agent of the owner. The claimant's burden of proof may then be assisted by a presumption of a contract of service or agency which the law imposes. Where a claimant in an action for negligence proves that damage had been caused to him by the negligent driving of the defendant's vehicle, the fact of ownership of the vehicle is prima facie evidence that the vehicle was being driven at the material time by the servant or agent of the owner or the owner himself. It is for the defendant owner to bring evidence to rebut the presumption and avoid liability. In South and Bryan and Confidence Bus Service Limited, Bryan was employed by the bus company as a driver. He had general authority to drive the company's vehicle, such authority not being limited to driving on the official route. Whilst reversing the bus at a gas station about a quarter mile from the nearest point of his normal route, he negligently collided with and damaged articles belonging to the plaintiff. There was no evidence to indicate that what took Bryan to the gas station, but there was not any evidence that he was acting on a frolic of his own, and therefore in that case he was held vicariously liable. The company was held vicariously liable for the driver's negligence. Liability for the torts of independent contractors. Imagine that you employ a firm of carpenters to repair a house, and one of the carpenters drop a hammer from the roof onto a passerby, injuring him. Are the carpenter and his employer the ones liable, or can the injured party make the owner of the house liable as well? The general rule is that the employer of an independent contractor is not liable for the torts committed by the contractor or his employees in the course of the job for which he is hired. There are exceptions, however, where the employer of the independent contractor authorizes the commission of the tort, 2 in cases of strict liability, and 3 in cases of non-delegable duties of care. So, authorization of the tort, where a party directs or instigates another party to commit a tort, both of them will be held liable for it. Where a passenger in a taxi orders the driver to drive fast or take other risks, both will be liable for any damage caused, for example. So in Ramessar and Tobago Electricity Commission to Ramessar and Tech, the defendants employed a tree felling contractor to clear an area of trees and vegetation in the course of preparation for the erection of power lines. The contractor felled a number of trees in such a way as to cover the plaintiff's timber, which was lying on the ground, thus depriving the plaintiff of access to the timber for several days. The plaintiff sued the defendants for negligence. It was held that the plaintiff's action was statute bar, but the defendants would otherwise have been liable for the negligence of their independent contractor because the acts complained of were precisely what the contractor had been employed to do. Strict liability. The employer of an independent contractor will be liable where the contractor commits a tort of strict liability, such as under the rule of Rylands and Fletcher, or under liability for dangerous animals. Liability in strict cases where the defendant will be held liable for damage caused by this act, irrespective of any fault of his part. So, in the case of Phillips and Barbados Light and Power Company Limited, a tractor was ploughing a field when it struck a stray wire fixed on the ground. The stay wire was part of the defendant's installation, erected for the purpose of supplying electricity to the district, and the wire was connected to a pole bearing the transmission line. The plaintiff, who was standing nearby, was struck by the wire and electrocuted. The plaintiff's widow brought an action on behalf of the estate relying on the rule in Rylands and Fletcher, and was held that the artificial generation of electricity was a non-natural user of land, and the escape of electrical energy of a lethal voltage was within the rule. But since the harm had been caused by the unforeseen act of a stranger, the defendant was not liable. And lastly, non-delegable duties. Where there has been neither authorization of the tort committed by the independent contractor nor strict liability, an injured party may still be able to make the employer liable if the duty of care can be said to be non-delegable. In such a case, the person does not discharge his duty of care merely by appointing, instructing, or supervising a competent contractor. Non-delegable duties arise where the projected work is intrinsically dangerous or hazardous and involves a high risk requiring special precautions. So in the case of Waste and Natural Gas Corporation, the corporation was authorized by statute to dig up the highway and to lay pipes. It employed an independent contractor to do the work. Owing to the contractor's negligence, a hole formed in the road after pipes had been laid. The plaintiff cyclist fell into one of the holes and sustained injuries. It was held that both the contractor and the corporation were liable. The corporation was not only under duty to take care, but also to see that care was taken. When a person employs a contractor to do work in a place where the public are in the habit of passing, which work will, unless precautions are taken, cause damage to the public, an obligation is thrown upon the person who orders the work to be done to see that the necessary precautions are taken, and if the necessary precautions are not taken, he cannot escape liability by seeking to throw the blame on the contractor. And that's the end of vicarious liability. Like and subscribe and stay tuned for more videos.